Namaskar. Welcome to online course on Indian Constitution which is being offered by NALSAR University of Law and is sponsored by Ministry of Law and Justice, Government of India. In the last lecture we talked about freedom of religion and went until Article 28. Now Articles 29 and 30 talk of what are called minorities, educational and cultural rights. So in today's lecture, we would see why minority rights are important, who is a minority, are Hindus too a minority in India, in some states, in certain conditions, are minority rights absolute, can a state regulate them, do minorities have a right to maladminister, can there be aided minority institutions, and what kind of reservation can be there in a minority educational institution. So what are the constitutional provisions on the minority rights? In the previous lecture, as I said in the beginning, we discussed Articles 25 to 28, which guarantee freedom of religion and guarantee right to profess, practice and propagate one's religion. Article 26 talks of substantial autonomy of religious denominations or any section thereof. Now Articles 29 and 30, they appear under the heading cultural and educational rights. Justice H.R. Khanna highlighted the significance of these provisions in the 9-judge bench judgment of Supreme Court in Ahmedabad St. Xavier's College. And he said, these provisions enshrine a befitting pledge to the minorities in the constitution of the country whose greatest son had laid down his life for the protection of the minorities. As long as the constitution stands as it is today, no tampering with those rights can be countenanced. Any attempt to do so would be not only an act of breach of faith, it would be constitutionally impermissible. And that is why you see our Supreme Court has held that minority rights are part of the basic structure of the Constitution and it cannot be deleted even by a constitutional amendment. Now let us go deeper into Article 29. Is it really the right of minorities? Though the head note of Article 29 says, protection of interests of minorities. But word minority is missing from the actual text of Article 29. In fact, if you read Article 29, you will see that Article 29 clause 1 says, any sections of Indian citizens having a distinct language, script or culture of its own shall have the right to conserve the same. Therefore, Article 29 is not a right of a minority. It is a right each and every citizen of India can claim if that citizen has his own distinct language, script or culture. And then Article 29 clause 2 says, no citizen shall be denied admission in any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. Article 30 talks of two kinds of minorities. That is, minorities whether based on religion or language. It does not talk of sexual minorities. It does not talk of other non-dominant groups. Article 30 gives religious and linguistic minorities equal rights And since both kinds of minorities have come together and have been clubbed together, Supreme Court has consistently held that minorities are to be defined at the state level as states were carved out on the linguistic lines. India has a huge religious and linguistic diversity, and therefore minority rights are not rights of just Muslims and Christians. Are Hindus too entitled to minority rights? Many of us believe that minority rights are rights of non-Hindus. Indian Supreme Court had adopted the numerical inferiority test and not the powerlessness test in defining minorities. Accordingly, minorities are defined at the level of a state. Anyone who is less than 50% in a state is a minority. Thus, in certain states of Northeast, Punjab, and Union Territory of Jammu and Kashmir, Hindus are religious minority. In all other states, Hindus are also entitled to minority rights as linguistic minorities. What are the educational rights of minorities? We are aware that now Article 21A provides that state shall provide free and compulsory education to all the children of the age of 6 to 14. New education policy proposes to further expand it. Right to Education Act was passed in 2009 to give effect to this constitutional amendment. Article 30 is the additional guarantee, a special right given to minorities to establish and administer educational institutions of their choice. Now, Supreme Court in In Re Kerala Education Bill, it's a leading advisory opinion of the Supreme Court of 1957, observed the key to the understanding of true meaning and implication of the article under consideration are words of their own choice. Supreme Court said, the dominant word is choice, and the content that article is as wide as the choice of the particular minority community may make it. Therefore, under Article 30, it is the minority which makes a choice, and it is within the powers of the minority to expand its choice as much as it wants. Minorities can establish educational institutions. What is the meaning of educational institution? What is the meaning of establish? Minorities can administer their institutions. What is the meaning of administer? Supreme Court said term educational institution includes a university. Therefore, there can be a minority university. Supreme Court also said term establish means to found, to bring into existence. In TMA Pi Foundation judgment of the Supreme Court, 11 judge bench judgment, Supreme Court said that this education includes education at all levels. So university education would be covered. So under Article 30, minorities are free to set up educational institutions of secular and modern education. You may recall under Article 26, religious denominations or any section thereof can establish and administer religious and charitable institutions. So madrasas are not established under Article 30. They are established under Article 26. Under Article 30, we are talking of modern, liberal, secular education. What is the meaning of right to administer? Right to administer means right to do day-to-day administration. It includes right to admit students, right to fix fees, right to choose governing body, and right to discipline employees. By the way, these rights are also available to all non-minority institutions as well. NALSAR University of Law has every right to fix its fees. Its governing body is as per its act. It has every right to discipline its employees. So these rights, right to administer, in this sense are common. But then there are special ingredients of administration which are available only to religious and linguistic minorities. Are minority rights absolute? Yes and no. Why yes? Because if you look at the text of Article 30, you will find that unlike fundamental rights under Article 19, 21 and 25, Article 30 does not mention any restriction in the text of Article 30. In Article 19, from clauses 2 to 6, number of restrictions are mentioned. In Article 25, the opening words themselves are restrictions subject to public order, health, morality, and other provisions of this part. Article 21, you have a right to life and personal liberty, but this right can be taken away under the procedure established by law. When it comes to Article 30, Indian Constitution, textually speaking, does not incorporate or mention any restriction. So it is yes. But then, in India, our laws are interpreted by the courts. And whatever Supreme Court says becomes binding on all courts throughout the territory of India under Article 141. So our Supreme Court has consistently held that no right can be absolute. So the answer becomes no. Minority rights cannot be absolute. Accordingly, municipal and health regulations would be equally applicable on the minority institutions. A minority institution cannot say, we will construct building without taking permission from the municipal authorities. No, they don't have that right. UGC has prescribed that for these many students, you should have these many toilets. No minority institution has a right to say that we will not follow UGC regulations. Similarly, educational qualifications for the appointment of teachers, appointment of the principal, appointment of the vice chancellor are decided by UGC, and minority educational institutions are bound by that. Can government regulate minority institutions? Yes. In Ahmedabad St. Xavier's College judgment, Supreme Court said regulation must be in the interest of minorities, not general public. So a state can come up with regulations. In Reverend Siddhaj Bhai Sabhai versus the state of Bombay, 1962 judgment of the Supreme Court said every government regulation must satisfy a dual test. One, just like Article 19, the test of reasonableness, that the government regulation is reasonable. And two, that this regulation must be regulative of the educational character of the institution and is conducive to making institution an effective vehicle for the education of the minority community or other persons who resort to it. So regulations are permissible. The regulations must be in the interest of the minority educational institutions to make them more efficient. Can there be an aided minority educational institution? Yes. There are many such institutions, like St. Stephen's College. Article 30, Clause 2 says, state in granting aid to educational institutions will not discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. No educational institution has a right to get state aid. But if a state is giving aid, in giving aid, state will not discriminate against minority educational institutions. In St. Stephen's College versus University of Delhi, Supreme Court said government aid cannot come with such conditions that would virtually deprive minorities of their rights. Similarly, government regulations of recognition or affiliation or aid cannot be destructive or annihilative of minority character of minority educational institution. We also have statutory commissions. There is a National Minorities Commission, and then you have a special commission on education called National Minority Educational Institutions Commission to safeguard the rights of the minorities. Can there be minority reservation in admissions? Because Article 29(2) says there cannot be denial of admission on prohibited grounds of religion, race, etc., caste, etc. The relationship between Article 30, Clause 1 and Article 29, Clause 2 has been subject of litigation in many, many cases. Now the law has been made abundantly clear. There can be a reservation for the minority communities in a minority institution. If it is a religious minority institution, the reservation would be for the religious minority. If it is a linguistic minority institution, the reservation would be for the linguistic minority. Now Article 15, Clause 5 and Article 15, Clause 6 explicitly exempt minority educational institutions from states' policies of reservation. So SC, ST, OBC reservation, etc. is not applicable on a minority educational institution. The reason is that minority institutions are catering the need of a specialized group. And therefore, in those institutions, there will be seats reserved for those groups. But I personally believe that minority educational institutions should also ensure that the diversity of the nation is reflected in those institutions. And therefore, they must make efforts to get SCs and STs and OBC students. What did we learn today? Minority rights are both for religious as well as linguistic minorities. Minorities are defined not at the national level, but at the level of a state. These rights are not absolute. Government has the power to regulate minority educational institutions. In the next lecture, we would discuss the relationship between fundamental rights and directive principles. Thank you very much. Namaskar.